Assalamualaikum and good afternoon, guys. Welcome back to Hello MECA. As always, I'm your host, Dzulfadhli Lamin, and I'm one of the consultants here at MECA. With the current Conditional Movement Control Order extension, which lasts until 9 June, I hope all of our members and viewers will maintain safe and comfortable wherever you may be, especially those who have reported for work. Don't forget to follow the SOP guidelines for your respected industries. We received great news yesterday from the ministry. We are now allowed to visit our relatives on the first day of Raya, Hari Wesak, and Hari Gawai. Yay! However, please remember that you are only entitled for a maximum of 20 people per visit. And nevertheless, be mindful of the social distancing and always remember to sanitize. Always, guys. It's very important. In our previous video last Tuesday, we discussed about the consideration and obligation of employers under the new Conditional Movement Control Order. We also discussed the obligation and consideration under the Program Saringan Prihatin Pekeso, or PSPP. Some of the things we discussed are what are the employers' obligation during and before and during business operation, and how should employers deal with the screening test. If you missed that, kindly go to our FB page to check it out. And while you're there, don't forget to like and share the video. Before we move on to today's topic, I'd like to give a special shout out to our partner, Elabram HR Solutions. Elabram has 20 years of experience in providing HR solutions in Asian region. Some of the solutions they provide are executive search and staffing, recruitment, and HR outsourcing. Elabram also provides a state-of-the-art system called Workforce Management System, the WMS. WMS provides standout features such as mobile attendance with face recognition, anti-fraud detection, leave and claim applications. All of these features can be used by company and staff via mobile apps and managed by using a cloud, which in my opinion is very convenient, especially in this modern age of advanced technologies. So if you're interested to try out these features, feel free to contact them at their website, elabram.com, elabram.com. Now, let's get straight to our topic for today. We've been receiving questions and concerns regarding disciplinary proceedings during this pandemic period, where most staff, employees, and people are still working from home. So among the pressing questions are, how should employers deal with misconducts? What can the employers do? And what's the best approach to deal with the misconducts? Which lead us to the burning question of, how do we conduct domestic inquiry remotely? So we hope in this session, we will discuss the concerns and questions posed by our viewers and members. Joining me today, I will have two panel speakers. Firstly, I would like to invite a legal associate from Dharmen, Sivalingam and Partners, Ms. Pavalakodi Nadarajah.
Hey, hi Zul.
Hi, Ms. Paval. How are you?
Good. How are you?
Great. Great to have you here. And joining us today will be a consultant from MECA, Ms. Shao Min Ng.
Hi Zul. Hi everyone.
Hi, Dharmen.
Hi, Carmen. Hi.
Well, both you and Paval are looking great as always. Thank you for joining me today. Right. As I was telling our viewers, today we're going to discuss about the dying question of conducting domestic inquiry remotely. So to kickstart this topic today, can I just ask Shao Min, as a consultant, can you generally brief us what is a DI, domestic inquiry?
All right. Thank you, Zul. So basically, a DI, domestic inquiry, is a process of investigation by the employer, so that they can satisfy that an employee has indeed committed an act of misconduct before deciding on a reasonable punishment. So it is just that simple. Yeah.
I see. So how do we deal with the DI knowing that everyone is away from the office? Pavel, how do we initiate a DI before we go into the remoteness of it? Generally, how do we initiate a proper DI?
Okay, so for DI, employers will start by issuing a show cause letter, followed by a DI notice, informing the employee about the DI hearing. Why they show cause is issued is to inform the employee about the alleged misconduct against them, and also to give them opportunity for them to reply. And only if the employer does not is not satisfied with the reply, then they will proceed to issue a DI notice and followed by a DI hearing. This is the normal procedure usually for DI.
So to say, if an employee has been accused of something, a DI is necessary for the employee to defend themselves and for the company to establish a case against the employee. Am I right?
You're absolutely right, Zul.
Okay, great. So now that from this topic on, how do we practically use a DI virtually? Okay, can I forward this to Shao Min?
Yeah, sure. So basically, in a conventional DI, like Powell said, show cause letter and notice of inquiry will be sent by letter. But in the situation that we are in, what we can do now is sending these documents through email instead of like the normal mail. So long it reaches the accused employee, I don't see any difference in sending it through normal mail and email because the details are still be presented to the accused employee, and we can actually save some money for not paying stamps. The email is just one click away. Another practical way to handle this domestic inquiry virtually is that the prosecutor should bear the responsibility and make sure that all the parties involved in the process are aware about the details. So most importantly, they should know about the date and time, and also making sure that these people have access to internet because everything is online. And another important thing is the parties involved will have to know how to use the platform. That's the practical side of it.
So can you just explain to the viewers who are the people normally involved in the DI?
Okay, so basically there would be 2 to 3 panel members, and the accused employee, the prosecutor, and if the prosecutor needs an assistant, the assistant can be there as well, and also someone who is going to jot down the minutes, and also the witness if the employee wants someone to help present his case.
Oh, I see. So everyone can still be managed through a virtual DI, right? So
Yes.
my next question will be, will a virtual DI defeat the principles of a normal DI?
I can start on this, Zul. I believe that whether it's virtual or conventional, principles of natural justice must be adhered to. Why? Simply because one of the principles of natural justice is audi alteram partem, which means that right to be heard. So both parties must be given right to be heard, and in this case, it must be given to the employee for them to defend or justify themselves. So yeah, whether it's virtual or conventional, it is necessary that these rules of natural justice are adhered to.
I see. Okay, that's great.
Powell, can I explain the next principle?
Yeah, sure.
Sure.
So the next principle is actually nemo judex. It means that no one is judged in his own case. Basically, in layman terms, it means that no person can judge a case which he has interest in. To apply this in a DI, in a virtual DI process, means that we need to select panel members in a particular not related to the accused employee at all.
Oh, okay.
So, for example, to ease your understanding, for example, if in a situation whereby the accused employee is a finance manager, then panel members for this DI should not be somebody who is from the finance department. So this eliminates the biasness, and this is the main objective for the principle, to not have bias and unfairness to the DI process.
So to briefly sum up, there are 2 important principles, or I would call, as Pavel mentioned, natural justice principles, which is first is the right to be heard, and second is to avoid biasness. So by having a virtual, it will not affect these 2, right? Or is there some concerns that we need to know of?
I personally, I do not think there's a difference because it's still the same. Whereby if it's a virtual, you still select the employees who are not in the same department. So I don't think there is any problem in this situation. Yeah.
So
Yeah,
as
I
long
totally
as
agree with Shao Min.
okay, so as long as these two principles are adhered to, it's fine to do a virtual DI. Okay, that's
Yes.
great. So moving on to the second question, can I ask Pavel, as a lawyer in this case? So normally in a DI, I am made to understand that the accused have been given a chance to justify or to put to put a defense. So that would also involve documentations and evidences. Will it be different from a virtual and a conventional DI? Will documents and evidences be, I don't know, in any problem?
I guess that's the biggest difference here between the virtual DI and conventional DI, because in conventional DI, usually prosecutor will be ready with the documents, all the evidence, and it will be tendered during the hearing, right? By hand. I mean, he will be tendering while he's presenting it to the panel. But
Yeah.
here it will be a bit different because he can't do the same like how it will be done in conventional manner. So that's the difference here. So what can be done is these documents can be shared among the panel members and employee via Google link. And also, while he is referring to the particular documents, he can actually share screen with all these members. So that's the biggest difference here.
So God bless technology, right?
Yeah, absolutely.
So in that case, Charmaine, practically for our viewers out there who is going to handle DR anytime soon, a DI anytime soon, do you have any practical platforms that they can go into?
So I think I can list down 3 platforms that can be easily be used and accessible. So first of all is Zoom, and then Microsoft Team, and also Skype. But based on experience, like our consultants meeting and whatnot, I would say Zoom will be the best. This is not a
Mm.
sponsored post. So Zoom, because of all the functions, like you can share your screen, you can even name the person. So as a host, if I am the host, I can name this person as accused, I can name this person as panel members, so that there wouldn't be a confusion. Yeah.
I
So
see.
three of them: Microsoft Teams, Zoom, and also Skype.
I think we should inform these 3 that we are promoting their products, right? Okay, nonetheless, you also earlier you mentioned something about a witness. So I can imagine in a normal situation during the process we call in witnesses into the room, testify, and they leave. So virtually, can we do that?
Of course, of course. So basically, like I mentioned, the prosecutor will now, in a virtual DI, he will be the host. So before the whole session starts, the host will have to send a link to the witness. And then when the witness press into a link, he will be automatically bring into this space. And then only when the witness is needed in the situation, then the host will be able to bring him inside the conversation. And when he's not needed anymore, then the witness can be just disconnected easily.
I see. So just like a normal DI, in and out as normal. Right. So next question will be on the evidences. So let's say in many cases, oh, I think we lost Xiaomi. Okay, I think she'll reconnect soon. Okay, nonetheless, Pava, in a situation where evidences are needed, there will be CCTV recordings, for instance. So let's say in a case of people sleeping at work, just
Mhm.
as an example. So they will have CCTV recordings, and to avoid these things from being viral, knowing that technology nowadays is so easy to viral stuff, what are the precautionary steps needed in tendering evidences during a virtual DI?
Okay, I would suggest if the evidence consists of CCTV, video, or any audio recordings, best not to share it with the employee. What they can do is, while they are presenting, they can actually share screen. They
I
can
see.
hear it or they can watch it. Why we are saying this? This is purely my opinion. Why I'm saying this? In case if this case lands in court, this will be a primary evidence against the employee. So the last thing we want is this evidence is being circulated in social media or being tampered with. So that's why I'm suggesting it's for this kind of evidence, it's better not to be shared. Better not to be sent via email or Google link. Instead, just share screen during the hearing itself. And if the employee wants to listen to it again, no problem. The prosecutor can play it again and again.
Again, God bless technology. Right. You mentioned a bit of court just now. So let's say if this DI will end up in court one day, maybe because the employee is not agreed to the punishment given. So
Right.
what is the weight of a virtual DI in the real court?
Okay, I believe actually this is an advantage. Why? Because in usual DI, only the DI minutes will be tendered in court, and most of the time, the DI minutes might not be accurate. It cannot show the demeanor of the employee, how the question was posted, whether the rules of natural justice has really been adhered to. But having a virtual DI, the company may actually record the entire DI hearing, and this will be a primary evidence in court. Whether the rules of natural justice have been adhered to, and what was his demeanor, what was his answers, whether is it different from his defense or answers in court now. You see, we will have opportunity to observe all this. So I would say it's an advantage to the employer and even to the employee as well.
So in the minutes, there will be no loss in translation, I would assume.
Absolutely.
That is a very great answer. I would like to pick on that question for a while, Paval. Let's
Yes.
assume a virtual or conventional. Is DI really necessary though for a disciplinary action?
It is absolutely necessary, I would say. Why? Because we are saying that while conducting DI and meting out punishment, rules of natural justice has to be adhered to. So how these rules of natural justice can be adhered? By giving the employee right to be heard. He must be given the opportunity to know what are the allegations against him. Number two, for him to come up with his defense or justification as if he really had done it, why he had done so. So only then the employee can reasonably come up with a reasonable punishment, I would say. So it is really necessary.
I see, great.
Can I chip in a bit from
Yeah.
an advanced perspective?
Yes, sure.
I would say it is always advisable to have a DI. Like I said before, it is to make so sure that the employee is not wrongly accused. So basically, the law actually states that due inquiry must be done before the punishment, but it doesn't really specify what constitutes to due inquiry. And based on experience, DI is one of the best practice to conduct due inquiry.
Okay. So that having a DI would not leave any questions unanswered, right?
That's right.
Yes,
On
totally.
that point itself, I was just wondering, like, how is it like, let's say if a show cause has been given to an employee and then that employee admits to the guilt or admits guilty, is DI necessary still?
It depends. I would say it depends on the nature of the misconduct. If let's say it's a grave misconduct, like it involves any criminal action like theft or any sort of nature, and the show cause is very clear, and let's say after receiving the show cause, the employee actually admitted to the guilt. Yeah. So the reason why we are having all this process is to ensure that he being heard, one. Number two, he's given opportunity to provide explanation. Here, since show cause is also an opportunity for him, right? And he had replied by admitting. And if the company felt that whatever evidence that they are having on hand is sufficient enough to establish guilt, yeah, why not? That it won't be really necessary to go for DI because based on case laws, not having DI is not fatal, but it's just that it's always a best practice to follow, I would say.
I see. So that also saves time, right? If at least when the
Yeah.
court asks, the company has done all they can to prove the guilt of the person.
But once again, Zul, I would like to stress that if the company choose not to have a DI, they should have a reasonable ground as to why they are departing from follow the normal standard procedure of having DI. In case if this case lands in court, so they will have justifiable grounds as to why they did not conduct a DI in this matter. So yeah, that's also important for the company to ensure it.
Okay, I think that's very clear for our viewers. I would like to also shout out to our viewers. If you have any questions for these two beautiful panelists, kindly drop your comments in our FB page session, and we will try to answer the questions at the end of this session. Right, moving on to my next question. Because we are now discussing on a virtual DI, there is a chance that in that virtual DI, the accused person may have help externally from lawyers. Let's say like you're facing me face to face from a camera, but you never know if I have 5 lawyers behind my laptop here giving me advices. So how do you deal with that?
Okay. Can I answer this question?
Yeah, sure, please.
Yeah.
Right. So I do understand from the view of an employer, whereby the employee can get extra help in this kind of DI process. Like Zoe mentioned, maybe in front of me there are like 5 lawyers there. But in my opinion, I do not see much difference, because even in a conventional DI, what we used to do was sending the notice of inquiry beforehand. And between the time where the notice was sent and the DI itself, the accused employee may also get external help. Like you will never know, like he will go and ask help from the other lawyers. So I wouldn't say there is much difference. And what employers actually need to keep in mind is that they do not need to be so worried as long as the company knows what they are doing. And since we cannot control the things that are not within our boundaries, just make sure that we are well prepared and have in hand what we really need. And I do not think lawyers should be worried about the situation. Yeah.
If I may chip in, Zul, I just have this to add on. See, like what Shao Min said earlier, the one thing they can do to prevent this is probably when they are issuing the DI notice, the usual DI notice will only contain charges, the date, time, and place of the DI hearing. But here, instead of having the venue of the hearing, they can inform the employee in advance that this is going to be a video conferencing, and also can put a note there that while attending this DI hearing, the employee should try to choose an isolated place so that he can attend the hearing without any interference. Because the last thing you want to know is while this DI is going, the employee might have a so-called lawyer uncle or an auntie who suddenly jumps in or interfere, right? So it will be good if the employer can actually give him notice in advance. Yeah, so that he can't avoid by saying this was not told to me earlier, I didn't realize about this. And also you want him to be ready and know that it's going to be a video conferencing instead of audio or something else. Yeah, so this has to be specifically stated in the DI notice. That is the difference when we are having a virtual DI, I would say.
I see. So in a virtual DI, you need to have more terms and conditions for having the DI rather than in person in a normal DI.
Yes, he needs to be told about all this in advance so that he can get himself prepared.
Okay, so in a normal DI, after the process is over, the panelists will discuss among themselves regarding the findings of the DI. So practically, can virtual DI do the same? Shao Min, what do you think on that?
Yes, of course. Again, I don't think there's any problem. So post DI, one of the things that will happen is that the accused employee will receive a copy of the minutes, and after that a letter informing punishment if he's found guilty. And like I mentioned before this, these kind of documents can always be sent through email. And back to your question about the panel discussion that is supposed to happen after a DI. Again, no problem. Because, okay, let's use Zoom as an example. After the DI ended, so everyone is supposed to leave the conversation and only the panelists will stay and discuss on and come up with their conclusion. So in a Zoom call, you can easily track how many participants is in the conversation. So if any other people who are not the panel members decide to stay, you can always disconnect them. There is no worry that anybody will always be on the call listening to all this kind of discussion. Also, if the panel members can actually choose to have their discussion in a new chat. So basically, you can just end the call and create a link for another call. It's really, really easy.
Nice. That's really good to know. And it sounds more convenient as well, right? You can just, with a click, you can disconnect that person.
Yes. You don't need to wait for the people to get out of the room and that kind of thing. It's just one. Yeah.
All right. So now that we have discussed briefly on how to conduct a virtual DI, and we are made to understand that there's no difference much between a real and a virtual, that are also advantageous to the virtual one. Do you mind sharing with the viewers if there are any more examples of advantages using a virtual DI in the new normal?
Shao Min? Okay, I shall go first on this, yeah? Okay. One of the best thing is here you will have a video recording of the entire DI process. Number two, the video recording can be readily accessed. You can have a transcript for it. Of course, it will be a better evidence in court. It will be the primary evidence. An employer can use this to establish whether a prima facie case has been made out by the employer. Okay, and also,
you mentioned prima facie. Can you explain to us what prima facie is?
Okay, prima facie case, in simple terms, it means that whether the employer have sufficient evidence to prove the allegation or the fact of his case. Provided it's not rebutted, it is sufficient enough for the court to come up with an award which favors the employer. So this is where usually the burden shifts to the employee.
Okay. Great. So it's easier to set up a case in front virtually, right?
Yeah. It's a lot easier, and I would say it will be very much helpful in tendering a primary evidence in court. And also, one more thing, Zul, I forgot about it earlier. Here, having a virtual, you can actually select a panel from anywhere in the world. It need not to be only the people from the company, right? It can be anybody, so long they are qualified. Of course, they are qualified to be a panel. So they can easily become a member of the panel.
Oh, I think that's a great idea because there's no more limitation of physical appearance, right?
Absolutely, yeah. Exactly.
If you want an expert from another country, it's more possible to have it virtually. Okay.
And even our MECA consultants can be one of the panelists. Why not? If let's say some of the employers, they might be very new to this. They might not have done a DI before. They might be worried because as it is, it's the first time they are conducting a DI and it's a virtual DI. So they might have a lot of concerns. So our MECA consultants can, provide consulting on this, or also can become a panel member.
I see Shao Min happily to hear that.
I'm sure Shao Min have done this before.
Yeah. Shao Min, I've heard that you've done.
Haven't done a virtual DI, but any clients or any person who want this face to be in the video call, that's fine. Just look for me. To add on to what Power has said just now, I would say having a virtual DI, especially during this period, CMCO, is so much useful because we are supposed to avoid the 3 Cs. So crowded place, confined space, and close conversation. Ironically, a conventional DI actually ticked 2 of those boxes, where a few of the people would be in a confined space having close conversations. So by conducting a DI online, all this can be avoided. And yeah, I would say it's very useful.
Okay, great.
And also another thing to add on, in a virtual DI, since we are able to record the whole process, so there's one less person involved because it can be used as minutes. So there shouldn't be someone who is just beside there typing out the minutes.
Okay, great. That's very good to know. I think we've covered mostly on how it's possible to have a virtual DI and the advantages of having the DI. If you girls don't mind, can I ask a question I received a few days back from one of our members?
Sure, Zul.
This is in a case of absenteeism, right? So normally in this kind of period where companies already started to operate, some employees may still refuse to come to the office, right? And this will also amount to a misconduct. Correct me if I'm wrong, but this also may amount to a misconduct, maybe an insubordination, maybe absenteeism. So can the DI here covers those kind of misconduct, or are there any misconducts that cannot be covered by a DI?
I guess any sort of misconduct can be covered here. I don't see why not. Because it's all about giving him, informing him, giving him right to be heard, and also deciding or determine his guilt through DI. So I don't see there will be any exception to any of the misconducts. I guess
Great.
all the misconducts can be included in virtual DI, I would say. Right, Shao Min?
Yes, I would totally
Okay.
agree on that.
Great. So I'll just reply to my client to say that. Because maybe, there are a lot of misconduct issues right now, especially when companies have started to operate. Business needs people in their offices, but a lot of employees still, I would say, refuses to come to the office. So having this DI is, I would say, to the viewers, an alternative to deal with the problems, right? Okay. I see there's a lot of questions coming in the FB questions. But before I move on to the questions, I would like just to make a very short shout out to our partners, Elabram HR Solutions. As I mentioned earlier, they have a state-of-the-art system called WMS. And the great thing now is Elabram is providing a free trial for WMS until the 31st May. So remember, WMS is able to support staff to work from home and remotely, especially during this kind of period. And I'm sure many of you are looking for solutions to handle these kind of issues. So these Elabram people are your reasons to go and contact them to get more details and to sign up for free. So don't miss out this chance to venture yourself and your company into the new era of modern technology. Right. Also, I would like to mention that in the past several sessions, we have been receiving overwhelming questions, and we have been actively answering the question and concern coming from viewers, especially those who have signed up for 14 days trial. I would like to make a shout out to the viewers today that MECA is also providing a 14 days trial, and like the past videos, a lot of people have subscribed and are benefiting from what we provide to our members. So please drop us your email, your profile, and your details to admin@meca.com.my to claim the amazing benefits. Right. Now I'm going to move on to FAQs. I will try my best to answer all of the questions. Let me pull up the first one. All right, this is from Butra Eda. Can we send the letter through WhatsApp if the person doesn't have an email? Interesting. Shao Min, what do you think of this?
Yeah, I think it is great. Since that person doesn't have email and nowadays WhatsApp has the option of sending a document, I wouldn't see there's a problem. Yeah,
As long as the person receives the letter as I should.
Yes. It works the same as an email anyway.
So Butra, I think besides WhatsApp, you can also use other platforms such as Telegram or if any so Instagram, as long as it reaches the person. That's the main objective. Okay, let's move on to the next question. This is from Jenny B. Supo. Can we have an external party as one of the DI panel? This is to meet the impartiality rule. Interesting. Pavel, legal perspective, what do you think of this?
Like what I've said before, of course, why not? So long the person is qualified.
So when you mentioned qualified there, I also remember Shao Min mentioning somebody not from the same department or having a higher knowledge on this? Can you give an example of this case?
Yes, it should be a person of equal level or of a higher ranking than the employee. So that's the usual standard. So yeah, so long the person is of equal level or higher standard. Here, equal level, what I meant is the job position. Yeah, it's not any other standard. The level we are referring here is referring to the position of the particular person, whether they are of a higher level or of the equal level of the employee. Yes, why not? Any external party may.
So that would say, as long as the person have the knowledge equal or higher, they can be a part of the panel members.
Exactly.
So in my company, just for example, I have 10 people, and the person being accused is somebody who is of a higher level. Is it possible for me to get an external from another company to help me with the DI?
Yes.
Okay.
It can be done. I mean, I don't see why it can't be done. See, it can be done. I believe so. Because obviously, if you cannot be getting someone who's of a lower ranking from the accused employee, right? So what you have suggested would be the best option then.
Okay, I think that answers you, Jenny. Hope you get that part in. Okay. I'm pulling out the second question. Sorry, okay. This is from KS Vani Selvaraj. What about the security issues involved in the virtual DI? Considering the risk of confidential issues being discussed, especially in Zoom. I think this would relate to the issues that Zoom had earlier on during the CMO period, right, where people are allowed to enter. If I may chip in, because I've been receiving, for instance, from Zoom update emails on their latest security updates. I believe that Zoom has solidified their security, and I'm pretty sure a lot of other platforms are doing the same. But nonetheless, Shao Min, about the security issue, I think let's deal with the evidences, for instance. What do you think of this? Will it be a worry to the employers?
First of all, I think if you have the latest version of Zoom, they actually give you like a private meeting ID and also a password. So I don't think there is much problem relating to this. And also confidential issues, because the documents or anything that has to be presented will be shared on screen. And I really don't think that there is any issues, because as like I said, if you have the latest version of the Zoom, they have updated their security issues. So yeah.
And I think I like the answer Paval and you gave earlier, where if you were to have any sensitive issues or confidential issues, instead of passing it to them, you can just share it on screen by the prosecutor or the host of the session, right?
Yes.
Okay, I think that's another advantages of having a technology so advanced. I think that answers your question, Vani Silveraj. Move on to the next one. This is from Nur Ain. Is it necessary to conduct DI for minor misconduct? We can do via issuance of letter and reply letter to the employee before proceed with judgment on penalty, right? As DI do take time. Evidence can be given via letter too, right? Screenshot, etc. This is very interesting. What do you think?
Can I chip in on this, Zoom? Okay,
Sure.
whether is it necessary to conduct, whether it's minor or major, I feel that DI is necessary, because DI is where you determine the guilt, unless, like what I've said earlier, he had admitted in his reply to show cause, right? What if it's a minor misconduct, but then the employee outrightly denied in his reply to show cause? Then here the company obviously cannot mete out punishment, right? So there is a necessity in this kind of situation for the employers to actually conduct a DI hearing. So I would say it depends on the circumstances of each case.
I think also you mentioned something about proportionate punishment earlier in our session. So I think it's important and clear to have a DI to ensure that the punishment given is proportionate. Or in a Malay,
Yes.
sekufu in
That's
Malay
right.
means sama level, right? So if you do this much of misconduct, this is the punishment that you'll be getting. And only through DI.
Whether the punishment meted out is commensurate with the misconduct. The DI is one way of considering that, because the panel will be advising on that, right?
Yeah. I know DI, they don't give the punishment, but however, the punishment always comes from the policies and the policies that you have in the company. So in order for you to reach out to the policy to take out the punishment, to implement, at least this DI has solved the issue whether or not this person is, I would say, layak to get the punishment.
And also sometimes they can come up with a suggestion. They don't decide what is the punishment, but they can come up with a suggestion on the punishment. Of course, it's up to the management to decide later.
Yeah. So the objective of a DI is to determine the guilt, guys. That's very important. So the punishment comes from your policy and handbook. If you have issues, policy and handbook, you can contact Shao Min. She's a great, excellent consultant there. Right, move on to the next question. This is from Alan Jacob. What if the accused employee requested for the copy of recorded DI? Can we share it?
For me, I always say it's not a problem. Okay, because usually everything is done, then the accused employee will also receive a minutes of the DI itself. So if the copy of DI is recorded, it constitutes 2 minutes. So why not share it? Because we have nothing to hide, so it's fine.
Sure.
Yeah, absolutely.
Berani kerana benar. So if there's nothing to hide, Ellen, I don't think it's a problem for you to share the recorded DI. Okay, let's move on to the next question. This is from Winnie Chow. In this virtual DI, do we still need to prepare minutes, or the video recording is sufficient? I think this was answered very clearly by Shao Min and Paval. It constitutes the same, whereas now it's an advantage because instead of writing down minutes where, like Paval mentioned, some info may be left out, a video recording is in full. So I believe it's sufficient enough.
Yeah, and also Zul, if they still need, they can transcribe the video. They can send it for transcription, right? Then they can have both the transcript as well as the video.
So they have one soft copy and they have a hard copy of the thing.
Yeah,
great idea. Okay, move on to the next one. This is from Karin Ng Kamli. What if company do not have sufficient personnel to form the panel? I think Shao Min, you can take this on. You mentioned something earlier about external.
Yeah, I think Power has discussed this with us. Through a virtual DI, it is even easier to get someone, because not only you can get someone in Malaysia, in Malaysia you can get someone from overseas as well, as long as the person is qualified to be a panel in the DI. So if you do not have sufficient personnel, you can invite someone like an ex-judge or IR expert or someone from MECA.
Yes. So Karin, I think that answers your question. If you do not have enough people in your company, it's always advisable to get people from outside. So this will, at the end, suffice to the two natural justice points covered in today's session. Right. Let's take one more question. We still have a few minutes left. This is from Lai Yi. If the person not acknowledge receipt of the show cause letter that we send via email, will there be any consequences for us? Legally speaking, what do you think, Papa?
Okay. See, what is important for us to ensure is that the show cause letter has been communicated to the employee. The employee has received the letter. If you feel that the employee have received but is not acknowledging receipt of the email, why don't you try any other mode, like what Shao Min said earlier, maybe WhatsApp. WhatsApp, you can clearly have the blue tick, right, where the person have actually received and read, or any other mode like Telegram or any other mode of communication, just for the company to ensure that he had actually received it.
So is it okay for me to summarize that in the action of giving a show cause letter, the employer has more responsibility in ensuring the employee receive the letter in any
Yes.
means. Oh, okay. I
Actually,
hope. Yes.
if you don't mind, like if you are worried of this kind of situation, you can also send an email and register post. So it shows that the employer actually make all the reasonable attempts to serve the letter, and the employee
Mm,
cannot come back and say that, oh, you only send it through email. But we have proof that we have tried all the reasonable attempts.
great answer. I think also in court, Pavel, can you enlighten us on the postal rule? I think once it's out, how is it considered as caught? Can the person still say, "Oh, I never received it"? Can the person say employer is not
Um,
doing their job?
so long we do have the acknowledgement of receipt, then there is no argument on that, right? So like
Mm.
what Shao Min said, if you are afraid of this kind of incidents happening, so why don't send via 2-3 modes? I mean, don't just give away the show cause in one way. Instead, try to do it in many other separate modes just to ensure that he had received it.
I think if I may chime in on this question also, I think it's important for you to identify the employees being accused. If the employee is easily connected, then it's okay to send via one platform, let's say WhatsApp or email. But if you think that the employee itself may have problems receiving, may have problems acknowledging, like what Pavel and Shao Min, try to go the extra mile in giving out the show cause letter. Okay, I hope that answers you, Lai Yi. Next question. This is from, oh, hold on, sorry. This is from Julia Faz. Worker absent 3 consecutive days. Can I give show cause letter or do I need to carry DI? I think it's it's a link there, right? Xiaomi, would you want to try this?
Yes, I would say to send a show cause letter first, because essentially a show cause letter is to give a chance to the employee to actually explain the situation. It's not, I guess a lot of employees, they have this misunderstanding that if they receive a show cause letter, they are already accused of committing a misconduct. So if a worker is absent for 3 consecutive days, I would suggest yes, send a show cause letter so that we know what is happening. Maybe he's really sick or something like that. And other than a show cause letter, I would suggest to maybe email this person, WhatsApp this person, call this person. Again, as employer, we should show that we have tried all the reasonable ways to reach this employee instead of just going to a punishment straight away. Yeah.
Okay, great.
Also, Zul, if I can add on to this question, yeah, it
Yeah.
is not an option whether show cause or DI. It's not an option. You have to always start off with a show cause, and then depending on the reply, you decide whether is a DI necessary or not. It always depends on the reply. If you are satisfied with the reply, there is no necessity for DI. If you are not satisfied with the reply, obviously you have to carry on a DI to determine the guilt of the employee. So it's not a show cause or DI. It
I
doesn't
see.
work that way.
Also, if I may add, just now earlier we mentioned that in any misconduct, a show cause is the first step to take. And then on, like you say, we
Yes.
depend on the reply. Okay, Julia,
Yes.
I hope we answered your question. Um, okay, there are a few more other questions, but I'm afraid that we are running out of time. But nonetheless, guys, the viewers, if you have or if you are planning to have a DI anytime soon and you are unsure whether the way you're conducting it is according as to what the law prescribes, you can drop an email to the consultants if you're a member, or you can call us at our consulting number, phone number. If you're not a member and you're interested to ask questions, please, by all means, drop in your email and your details to admin@MECA to enjoy the 14 days trial. And within that 14 days trial, we will try our best to help you out. Okay. So far, I think that's all we have for today. I would like to give a special and big thanks to Pavel and Shao Min. Thank you very much for joining me today and clarifying a lot of smoke in the air. Because I personally believe that disciplinary action must be taken quickly. You can't delay these things. So now
That's
we
right.
are discussing on a virtual approach. I think it's best and it's important for the HR practitioners and business owners out there to conduct the the disciplinary proceeding as quickly and as soon as you can. And now that we have this technology, Xiaomi had briefly told us what platforms we can use. I believe that there's no excuse employers to delay this kind of misconducts. All right. Again,
Thank you
thank
for
you very much, Pavel. Thank you very much, Xiaomin.
Thank you, Zul. Thank you, Shao Min.
All right. And to our viewers, thank you very much for tuning in. And for those fasting, selamat berbuka. For those celebrating Hari Gawai, Hari Wesak, get yourself prepared because it's not going to be cancelled this year. We still can celebrate from home. Other than that, until next time, see you guys again. Bye bye.
See you.